Good morning, everyone. I would like to welcome everyone to Assembly Judiciary. With that, Secretary, please take the roll.
Assemblywoman Bilbray Axelrod.
Here.
Assemblywoman Cohen.
Here.
Assemblywoman Considine.
Present.
Assemblywoman Gallant.
Here.
Assemblyman Gray.
Here.
Assemblywoman Hanson.
Here.
Assemblywoman Hardy.
Here.
Assemblywoman LaRue Hatch. Assemblywoman Marzola.
Here.
Assemblywoman Mosca.
Here.
Assemblywoman Newby.
Here.
Assemblyman Orentlicker.
Here.
Assemblywoman Summers Armstrong.
Present.
Assemblyman Urick. Chair Miller.
Here. And please mark the other members, or I think just one member, present when they arrive. With that, just a few reminders, asking everyone to turn off anything that will make any noise during the presentation. We also will have a public comment at the end of the hearing, and that phone number and member ID number is also listed in the agenda that you can find on Nellis. Today we have two hearings. The first one will be Assembly Bill 231, which will be presented by Assemblywoman Shea Backus. It revises various provisions of the Uniform Commercial Code. And so I will give the Assemblywoman a moment to get ready. And with that, I officially open the hearing. And Assemblywoman, please proceed when you're ready.
Thank you so much, Madam Chair and members of the Committee on Judiciary. For the record, I am Shea Backus, Assemblywoman for District 37. I am also a Nevada Commissioner to the National Conference of Commissioners on Uniform State Laws, often referred to as the Uniform Law Commission, or ULC. Today, it is my pleasure to introduce Assembly Bill 231 with Ben Orzeski, Legal Counsel for the Uniform Law Commission, and William S. Boyd, College of Law Professor Keith Rowley, who is also a ULC Commissioner. Professor Rowley and I are appointed to the ULC pursuant to Chapter 219 of the Nevada Revised Statutes, as well as Assemblyman Orlichter and also Assemblywoman Cohen, who are also in this committee. Prior to walking this committee through the bill, I want to provide you with a brief history of the Uniform Law Commission. The ULC was established in 1892 to provide states with nonpartisan, well-conceived, and well-drafted legislation. ULC's deliberative and uniquely open drafting process draws on the expertise of commissioners, but also utilizes input from legal experts and advisors and observers representing the views of other legal organizations and interests that will be subject to the proposed law. ULC stays up to date by addressing important and timely legal issues, such as the need for an amendment to the Uniform Commercial Code to address emerging technologies, including adding a new article. Before I turn this over to Mr. Orzeski and Professor Rowley, I want to give a high level of the Uniform Commercial Code, commonly referred to as the UCC, so that you have an understanding as to what this bill is exactly amending. The UCC is a comprehensive set of laws governing all commercial transactions in the U.S. and has been universally adopted by all states. While parties to any particular transaction can agree to the terms of their contract, the UCC is essentially default rules and provides legal certainty, giving strangers confidence to conduct business. At this time, Nevada has enacted 10 UCC articles, which is codified in Chapters 104 and 104A of the Nevada Revised Statutes. Article 1 provides general terms. Article 2 governs sale of goods. Article 2A governs leases of personal property, such as like a lease for construction equipment. Article 3 governs negotiable instruments, like a check. Article 4 governs bank deposits and collections. Article 4A provides a comprehensive body of law on the rights and obligations connected with fund transfers. Article 5 governs letters of credit, which are typically issued by a bank or other financial institution to its business customers in order to facilitate trade. Article 7 covers documents of title to personal property, such as bills of lading. Article 8 provides a modern legal structure for the system of holding securities through intermediaries. Article 9 provides a statutory framework that governs secured transactions involving personal property. And I just learned from the Secretary of State that that department collected nearly $3.5 million in revenue from UCC filings last year. At this time, I will turn this presentation of AB 231 over to Ben Orzeski, who will walk you through the sections of the proposed bill, and as well as Professor Rowley. Both will also be here to answer any questions that you may have.
Thank you. Am I recognized by the chair?
Yes, please proceed.
Okay, thank you. Madam Chair, members of the committee, my name is Ben Orzeski. I am the Chief Legislative Counsel at the Uniform Law Commission, and I want to thank Assemblywoman Backus for her excellent introduction of this bill. I won't go over the same ground. I do want to point out that the UCC is a law that, while it operates without most of us thinking about it from day to day, we all benefit from the fact that it's there and from the fact that it's uniform in every state. So, for instance, when you order something off of Amazon or eBay, generally we don't worry about what state the seller is in because the law is the same. And if something goes wrong with that transaction, you need a warranty claim or a refund or something, the rules are going to be the same under the Uniform Commercial Code. And similarly, Nevada businesses benefit from that uniformity because they can sell to customers in any state with the confidence that the rules will be the same. This is the reason why Americans have confidence generally to do business with strangers, which is not the case always in the rest of the world, and why our commercial markets have thrived relative to places elsewhere. So the bill you have in front of you is the first significant set of amendments to the Uniform Commercial Code in 12 years. And it has to do with emerging technologies that necessitated a few changes. Some of the changes are mundane. It's something as simple as changing the word writing to record, which will account for electronic documents and electronic signatures. The fact that you can now take a photo of your check and email it to your bank as a method for depositing it. That's a practice that the law had not caught up with, and now it will with these amendments. But the most significant addition is the new UCC Article 12 and the changes to UCC Article 9, both of which have to do with new types of property that we've termed controllable electronic records. This is an umbrella term. It includes blockchain assets such as virtual currency and non-fungible tokens. And we've defined it in using generic terms, a controllable electronic record, so that it also will include maybe other types of similar property that are yet to be invented, but will be over the coming years. Control is kind of the key element of this definition. Normally with an electronic record, which would just be a document or a photo, some piece of data, you could have as many copies as you like. We could all have a copy of a PDF document and they would be identical. With a controllable electronic record, one person retains control of that. So for instance, with virtual currency, if you own Bitcoins, only you can use those Bitcoins to spend them or transfer them to somebody else. And when you do, then the other person becomes the controller of those records. These amendments became necessary because the old rules of the Uniform Commercial Code didn't work very well for these new types of property. Under the current unamended UCC, virtual currency is classified as a general intangible. And the only way you can perfect a security interest if you want to loan to somebody and use virtual currency as collateral is by filing with the Secretary of State's office. There are some disadvantages for doing it that way. Under the new amended UCC, there are the lender can take control of the virtual currency by depositing it in their own account or maintaining a multi-signature arrangement so that it can't be spent without their permission. And that way the lender is better protected in the event a loan goes bad and they need to repossess the assets. There's actually a way to get at them, which there wasn't under the old rules. Just an example of why these rules were necessary. There's something in the UCC called a take-free rule, and an example is probably the best way to illustrate it. If you say you are a merchant, a grocery store, and you sell a cart full of groceries for $200 to a customer, under the UCC, that sale is final, and you don't have to worry about it being unwound as long as a few conditions are met, that you've given value in exchange for the money, and you don't know of another claim on the money. So if the next day a police detective walks into the grocery store and says that customer they didn't spend their own cash, they'd embezzled it from their employer, the rules are clear. The grocer is the innocent party in that situation, and that transaction is final. The grocer can't be sued to get the money back because they've given value and they didn't have knowledge of another claim. Well, those rules were not in place for virtual currency transactions, which is probably why most businesses don't want to accept virtual currency and why most banks don't want to lend against it. With the new rules, the rules for those transactions will be clear, and it should allow these markets to expand in a responsible and more mainstream way than they've currently been able to do so. With that, I'll stop. I'm going to remain on the hearings and would welcome your questions after the testimony of Mr. Rowley.
Good morning, Madam Chair. Good morning, members of the committee. My name is Keith Rowley. I am a William S. White Professor of Law at the University of Nevada, Las Vegas School of Law, and have been teaching UCC courses for the last quarter century, 22 years at UNLV, counting this year. I am a Uniform Law Commissioner. I'm also a member of the American Law Institute, both of which are the bodies that are responsible for the UCC. But participated in this process not as a member of the drafting committee, but as a very interested and active observer, as was the case with the 2010 amendments to UCC Article 9 that modernized some of the rules in Article 9 to try and deal with issues of identifying debtors for purposes of perfecting security interests and other things. Mr. Orzeski mentioned virtual currency, which is obviously was an important driving force in motivating the bodies to undertake first a study and then a drafting process to update the UCC. Another type of controllable electronic record that gets a lot of buzz in the news is what's commonly referred to as an NFT, a non-fungible token. Which isn't necessarily something that is spendable like virtual currency is, or at least could be, but is also in the eyes of many a valuable asset that would make up part of a person's portfolio of assets. And just as as virtual currency can be a controllable electronic record, so can an NFT under the amended statute, or under the amendments to the statute. Mr. Orzeski didn't mention, and I think it's worth mentioning, if for no other reason than based on my prior experience testifying before the legislature about amending the UCC and about other types of uniform laws related to my areas of specialty. 21 states in the District of Columbia have already introduced bills to enact these amendments. And those bills have passed at least one chamber of the legislature in half a dozen or more of those states, and both chambers in one state. So the train is rolling, and Nevada doesn't want to be left behind for the reasons that Mr. Orzeski mentioned. In availing Nevada businesses and also Nevada consumers of the protections that the UCC provides, and of a uniform commercial code, or at least as uniform as we can get it, is highly beneficial. The current version of the code, without getting too granular, the current version of the code does allow for personal property security interests in what we're calling now in the amendments controllable electronic records, including virtual currencies and NFTs. But the only way to perfect that interest, which is a key consideration for a lender who might be willing to take them as collateral, is by filing a financing statement with the Secretary of State's office in the relevant jurisdiction, or its counterpart under the statutes of another jurisdiction. And that's just not what crypto natives expect. They don't expect to have to move outside of the cryptocurrency space or the NFT space and go to an analog, even if it's electronic filing, they would still think of it as an analog, if not antiquated, um, separate system for filing notification of security interest. That also is significant concern about privacy. Part of the reason why some of these assets are so interesting to so many people is their ability to engage with them pseudonymously without having to give away all of their personal information. But if a lender were to take a security interest in somebody's holding of say, Ether, one of the popular virtual currencies, in order to perfect that interest, the lender would have to file a financing statement against that person with that person's name and that person's address listed on a financing statement filed with the Secretary of State's office. And that's, that's problematic for many people. So the idea of control as a substitute for, or as an addition to filing, and indeed a preferred addition to filing a financing statement, allows for a method of perfecting a security interest within the environment of cryptocurrency and blockchain technology without having to go outside. These assets will still be perfectible by filing as well, and anyone who is properly perfected by filing prior to the effective date of these amendments would still be perfected and would have a grace period within which to obtain perfection by control so as not to lose their priority over security interests of other parties that might have been perfected by control after control became available. Another motivating factor, it was dealing specifically with Bitcoin because of the definition of money that's in the Uniform Commercial Code in Article 1. As soon as El Salvador adopted Bitcoin as legal tender, Bitcoin fell out of what Article 9 deems to be money, and there became no way to perfect the security interest in Bitcoin. And given that it's the most valuable and highly sought after of the cryptocurrencies, that's a problem for a lot of people. And so we needed to come up with a way to enable a party with holding Bitcoin, someone holding Bitcoin, to perfect the security interest to grant a security interest that could be perfected in that Bitcoin, and control is the solution. There are, as Mr. Rozeski mentioned, there are a number of other changes to the code. Most of them are minor. Some of them are in places that don't directly have to do with evolving technology, but fix some things that had rules that had created problems for the courts and have or reflect sort of an antiquated worldview. And I'm happy to take questions about any of this, either now or to respond to any questions or issues that are raised by subsequent testimony, either during the hearing or subsequently by follow up by email or telephone conference or in-person meeting. I am your Nevada Uniform Commercial Code law professor. I am the only person who teaches these courses. At least have been for more than a decade at the William S. Boyd School of Law. So with that, I'll stop rather than trying to wade through the 120 pages of the bill, pointing out all of the changes that matter. But let me just say that it matters. It matters to the proper functioning of commercial law in the state of Nevada. It matters to the ability of Nevada parties to take advantage of the full advantage of the broader commercial law and commercial transaction system in the United States. And I strongly urge the committee to approve these amendments and pass the bill along to the next stage. Thank you.
Thank you for that. And I'm just giving the members a moment to collect any questions they may have. You've done such a thorough job of explaining. That's usually a sign when there's not a lot of questions. So we do have a few questions from Assemblywoman Cohen, who also is a uniform, right? A commissioner, so.
Yes, I am a commissioner, proudly a commissioner. But that doesn't mean I'm a commercial code person. Thank you for the presentation. So my first question is just about the process of the UCC and how many meetings, how many hours did the committee work on this update of the UCC? If approximately.
Sure. So there were over 3 years, about 18 meetings, started out in person and then during the pandemic moved to Zoom meetings. Those meetings included upwards of 250 observers representing all parts of the banking industry and virtual currency attorneys and virtual currency holders, and they helped us to craft these rules. In addition to those 18 full meetings, there were a number, probably another dozen or so subcommittee meetings of people who were working on specific issues, such as the definition of controllable electronic record, to kind of stress test and make sure that the rules we were drafting worked for everybody. The archive of all of that history is available on the Uniform Law Commission's website, all of the various iterations that the draft went through before the final amendments were approved.
Thank you. And these were lawyers, judges, technology experts, members of different states, legislative council bureaus, from all over the country, experts in these fields from all over the country.
Yes, the commissioners who were appointed to the committee are all attorneys, volunteers from the various states like yourself who work as commissioners, and they offer some expertise to come to the table. But the committees are open to anyone in the public. You don't have to be an attorney. And so a lot of people who are just involved in the virtual currency industry and wanted to make sure that the law evolved in a useful direction also participated, and certainly the committee sought out stakeholders from all of the groups that you've mentioned, anyone who'd be affected by this, to make sure that they were in the room and they could see the process and have a hand in developing what these amendments would become.
Thank you. Okay, and then
And if I,
oh, sorry, go ahead, Professor.
I'm sorry, I was just going to say, and if I may add, for those who couldn't be in the room for particular meetings, whether it was a live room or an in-person room or a virtual room, the committee also received numerous emails and letters from various individuals and groups that were interested in certain aspects of the proposed amendments, and took those well into consideration as well as what was said during the drafting meetings, and there were lively exchanges of emails among the committee members as well. So this was extremely carefully considered and a lengthy process that was designed to address all of the issues that were raised and come up with the best possible solution for adhering to the spirit of the Uniform Commercial Code.
Thank you. And then technically on the bill, I guess, so in practice, how does perfection work when we're talking about something that's crypto? If I have, if a bank perfects a lien against me and I own widgets and they, and eventually there's a lien and they can go and they can get the lien, they can get my widgets and they can resell them. Like how does that work with an NFT or cryptocurrency? I mean, how do they get what they're owed if in this new realm that we're working in?
Well, you put your finger on the problem exactly. There was no good way for the bank, for lender to take control of assets that were intangible and were on a blockchain. If all they could do was, when they were categorized as a general intangible, to perfect their security interest, was to file a financing statement. That didn't really give them control. So if the loan went bad, they were still vulnerable, might not be able to collect on it. What the new rules do is create this separate category of controllable electronic records and give priority to the lender that has control of assets over a lender who has only filed for it. And there's a period, a transition period, so that anyone who's filed under the old system is grandfathered in and maintains their priority until they have time to adjust to the new rules and adjust their lending agreements. But that was the problem. Under the new rules, a lender can take control of the assets, meaning they can either deposit them in their own account, in the lender's account, and hold them for the life of the loan, or they can have an arrangement where there's a joint holding, a multi-signature type agreement between the bank and the owner, so that the owner can't spend these or transfer them without the bank's permission. So either of those are permitted under the new rules.
And again, if I may add, the rules for controllable electronic records actually put a bank who has a lender or other lender who has taken a security interest in cryptocurrency or another form of controllable electronic record in a better position than they would be in had they, to use Assemblywoman Cohen's example, had they taken a security interest in widgets, which nobody knows exactly what a widget is, but we assume that it's a tangible object that we just use that as a placeholder. Because if the bank files to perfect, there's two ways to perfect the security interest in a tangible asset. One is to take possession of the asset, which is impractical in many cases. A construction business doesn't want to give possession of its earth mover and bulldozer to the bank while it pays off the loan that it's secured with those items. It wants to use them, and the bank wants them to use them so that they can make money to pay off the loan, which is the bank's ultimate goal. The other is to file a financing statement. If you've done that in the proper place and in the proper way, you've perfected your security interest. And then if the debtor defaults on the loan, you have the right to assert that security interest, through the process of either foreclosure or repossession. But that still requires going out and getting the bulldozer and the earth mover, or holding a sale of them without having possession of them, which tends not to produce a particularly good outcome at foreclosure sale. With the controllable electronic records, including but not limited to cryptocurrencies, the lender would have the credentials of the person to whom the controllable electronic record belonged at the time that the loan was created, and would be able to, upon default, would be able to initiate a transaction that would move that value. Without having to go through the process of repossession, or without having to conduct a foreclosure sale. And that just makes it far more efficient, which makes controllable electronic records a much more attractive type of collateral for lenders than these electronic assets currently are. And that will enable people who own them to borrow against them more easily and on better terms than they currently can. You don't go to the grocery store, typically speaking, and pay for your groceries in Bitcoin, because Bitcoin's far too valuable to break up, and the grocery stores wouldn't know how to break up something that's as valuable as a Bitcoin. But you can borrow against that, or at least you'll be able to borrow against that again once these amendments are enacted. Hold on to the upward value that the appreciation in value that might that the asset might realize, and use it to collateralize a loan that you can spend on day-to-day expenses. So it's I'll stop there. Again, I could go on for a while.
No, thank you. You answered that. You got to what I wasn't quite understanding.
Okay, thank you for that. Our next question is from Assemblywoman Bilbray Axelrod.
Thank you, Madam Chair, and thank you for being here. This is actually my first session that I haven't had a ULC bill that I'm carrying, so I'm feeling a little jealous right now. My question, you actually kind of touched on it. I've heard anecdotally, and I know you at the ULC do not deal in anecdotes at all, but that there have been stories where people have lost their credentials and therefore lost their Bitcoin. We this last session dealt a lot with blockchain technology, and so we heard a lot of those stories. Would this offer any consumer protection? I mean, I'm guessing with the banks having credentials when it has to do with loans, but what about just, your everyday person who purchased Bitcoin and then loses their credentials? And from what I understand, once again, anecdotally, it's gone forever.
Yeah, I don't think these amendments will help with that situation. Unfortunately, it's kind of a problem that's inherent in the system. The whole system is built on you having an access code, a key, in order to access your Bitcoin or whatever it is on the blockchain. So when people lose that code, unless the blockchain system itself has set up a system where there might be some way to recover it, but under the early blockchains, Bitcoin and others, there is no way to do that, and this bill won't change that.
I think that one protection that the bill might afford to some extent. I mean, the real answer for those problems is to enact something along the lines of the Regulation of Virtual Currency Businesses Act, which was introduced in Nevada several years ago, but didn't proceed and is slowly gaining traction. But there are other approaches that are slightly different, bills pending in California and Illinois that are inspired by, but are not verbatim, the Regulation of Virtual Currency Businesses Act. And I think that Senator Orenshaw is planning on reintroducing an act in this session, but perhaps that ship has sailed. I'm not sure what the timing rules are. To the extent that a third party, a bank or some other entity, is holding your virtual currency credentials for you, they would be subject under this act to the rules in Article 8 of the UCC, in the same way that securities intermediaries who hold your securities or your security entitlements, your shares of mutual funds or whatever they might be, on your behalf are, there are rules that govern what they can and can't do with them, and some of those are designed to protect the ultimate owner of the credentials. We've seen just in the past 6 or 8 months the failure of a major company platform that took virtual currency credentials from customers who believed that the platform was holding the virtual currency credentials for them, but in fact the platform was using the credentials for their own benefit, lost them, and now in bankruptcy in December or January, the bankruptcy court informed all of those customers of the platform that they didn't own anything. They didn't own the virtual currency that they had parked on the platform because of the way that the transaction between them and the platform was arranged. So there's some protection here. It's not as extensive as might be desired for protecting against all manner of things that can crop up when somebody else is holding your money or other valuable asset for you. But there's more available post enactment of these amendments than there is under current law.
Thank you for that. I have just one quick question. You mentioned earlier that, again, this is just to catch Nevada up with what the other states are doing. Do you have any idea where it is in the process? Like how many states have already adopted these amendments or changes?
Yes, no state has adopted them yet because they just became available. We published them in the fall, and so the sessions that began in January were the first opportunity to introduce this bill. 22 jurisdictions, 21 states plus DC, have bills pending, and I'm expecting somewhere between 5 and 10 more this year that I know are still in drafting, but not yet introduced in states where the sessions run later. So I expect that over a majority of states will introduce bills before the 2023 sessions end, where we'll have enacted bills, and that probably most of the rest in the next year.
Okay, thank you for that.
And if I may add, there also are 2 or 3 states that jumped the gun, if you will, and enacted legislation based on the most recently available at the time draft of these amendments. So Texas, Tennessee, if I recall correctly, although I could be wrong on Tennessee, New Hampshire, and at least one other got versions of these amendments already enacted with a pledge that they would come back, and they at least two of them already have, and introduced legislation to conform what they had passed in 21 or 22 based on the drafts of the amendments to conform their legislation to excuse me, to the final version of the amendment. So there's a little bit of this law already on the ground out there, although it's subject to a little scrubbing and polishing. But and by my count, which I don't think is current, the bills that are pending in one state have passed both chambers and are awaiting action by the governor, and in about a half dozen states have passed at least one of the chambers. The chamber in which the bills originated. So the states are moving on this, and as Mr. Rozeski said, moving as quickly as they can, except for the gun jumpers who didn't wait for the work to finish because the amendments have only been available for a few months.
Okay, thank you for that. Not seeing any additional questions from members, I will go ahead and open it up for testimony. So anyone that would like to testify in support of Assembly Bill 231 here in Carson City, please approach. Not seeing anyone here in Carson City. Broadcasting, can we open the lines?
Sure, the lines are open and working. There are no callers at this time.
Okay, thank you. Then I will go ahead and open it up for anyone in opposition of AB 231. Not seeing anyone here in Carson City. Is there anyone broadcasting, anyone on the lines?
Sure, there are no callers at this time.
I would like to open it up for testimony in neutral of Assembly Bill 231. Is there anyone here in Carson City that would like to testify? Not seeing anyone. Broadcasting, is there anyone on the line?
Sure, no callers have joined.
Okay, thank you. Then I will go ahead and close testimony and welcome the bill sponsor back up for any final remarks.
I just want to thank you guys for your time. I know it was a thick bill, lots of just conforming changes. I'd also like to thank Ben Orzeski, who I think may be on vacation, to give up his time to present with us today, as well as Professor Rowley. So thank you, everyone. I hope we can gain your support on this bill, and we'll be available to answer any questions that you may have later on. Thanks so much.
Thank you so much, Assemblywoman. With that, I will go ahead and close the hearing on Assembly Bill 231. Next on our agenda is Assembly Bill 238 that will be presented by Ms. Bridget Duffy. It revises provisions related to certain offenses involving concentrated cannabis. No, that is not what it is. My notes are, as I'm reading, I'm like, this sounds vaguely familiar and yet totally incorrect. Instead, Ms. Duffy, I did have that part correct. AB 238 establishes provisions related to commercially sexually exploited children. And so with that, I will open the hearing, and Ms. Duffy, please proceed.
Good morning, Chair Miller and members of the Assembly Judiciary. I am Assistant District Attorney Bridget Duffy from Clark County. I am the lucky recipient of the support of the Commission on Commercially Sexually Exploited Children, the statewide commission I testified to last Friday, to be the presenter of AB 238. So this bill is not coming from me in my position as an assistant DA, but is coming from the statewide Coalition on Commercially Sexually Exploited Children. So today is what I am presenting is that bill that I talked about and referred to last Friday when I presented AB 183, which is another interim bill that kind of marries the two together. The AB 183 was about assessments and screening of children to ensure we are providing the appropriate services for victims of sexual exploitation. And this is going to be about training and multidisciplinary teams. So as it's a long bill. I've tried to condense it to make it easy to walk through. So with the bill in front of you, sections 1 through 3, 5 and 6, 13, 15 to 21, 23 to 27, and 30 and 32 all require certain persons who interact with children as part of their employment to receive training concerning the identification of and assistance to commercially sexually exploited children and those who are at risk of that exploitation. So I saw there's probably about 13 different categories of people to be trained. They would include foster parents, employees of a child care facility. More commonly known for our child care facility is our emergency shelters. That would be our Child Haven facility, and I believe it's called Kid Cottage in Washoe and Child Haven in the south in Clark. It would require child welfare agency employees, attorneys who represent children that are in foster care, as well as attorneys who represent parents who have children in foster care. CASAs and our guardian ad litems. A CASA is a court-appointed special advocate. Juvenile justice agency employees, employees who work at our state-run correctional facilities for children. Those would be our Caliente, our Nevada Youth Training Center, and Summit View Training Center. Parents, attorneys in termination of parental rights proceedings. State public defenders who regularly work with children. Our Attorney General and his Deputy Attorney Generals who regularly work with children. The Attorney General Ombudsman. The district attorneys and district attorneys who regularly work with children. And school district personnel. That would include teachers, nurses, counselors, social workers, psychologists, resource officers, and those would be included in private schools as well as our public schools. So those are the categories of individuals that we would have receiving training in order to identify victims or potential victims of sex trafficking. And then you have sections 8 to 12, which amend NRS 432C to allow for the creation of multidisciplinary teams to review the cases of commercially sexually exploited children. The who can create those teams is in section 9, which would be a child welfare agency or other relevant agency of a local government. The best practices indicate that teams should, when possible, include child welfare representatives, district attorney representatives, law enforcement, school district reps, mental health representatives, representatives of local government that supports the needs of commercially sexually exploited children. So that would be our victim advocates or other advocates in our community. And then a catch-all of anyone else that the team would find appropriate to assist with their work. So what they would do is in section 10, they would look at various records, they would assess and analyze cases, they would ensure a coordinated response that meets the needs of a child throughout criminal justice process and processes to arrange services to the child. They would also make recommendations to improve laws, policies, and practices to better prevent and respond to cases. So you might see in the future bills coming forward out of those multidisciplinary teams. And another catch-all for what they may do, which is to take any action with the purpose of supporting the safety and well-being of children and preventing victimization and preventing the exploitation. Section 11 would allow for information sharing. That would include law enforcement information, medical or mental health information, social or rehabilitative services that have been provided by any social service agency, education information, juvenile justice information, and child welfare information. There is a section within Section 11 that would require the MDT, multidisciplinary team, to make efforts to get written permission of the person responsible for the welfare of the child prior to sharing records. So we would make efforts to get the parent or guardian or custodian's permission to share records among the agency, if we're able to. They are also to collect aggregated data, so that would be data that does not identify specific children, that could be used for research for prevention efforts. And it would also provides for confidentiality and exceptions to confidentiality, which would include criminal investigations and mandated reporting requirements. It also has a penalty for breaching that confidentiality, which would be the gross misdemeanor penalty. Section 12 creates an executive review committee. So this would be an oversight committee of each of the local MDTs. I'm going to keep saying multidisciplinary team. Sorry, I'm trying not to use the acronym. So that would be created and established by the Division of Child and Family Services within our executive branch. They would create the statewide protocols for the teams. They would adopt regulations to carry out those provisions. They would have their own bylaws created to govern the executive committee. They would oversee the training and development of the local MDTs. And they would also compile and distribute statewide annual reports, including stats and recommendations for regulatory and policy changes. So for that, to think about it, you have all these local multidisciplinary teams, and I know in both Washoe and Clark, we have them already operating. I can tell you a little bit about Clark's if you'd like to hear about it. And this would be an overarching executive team where the locals would go and talk to the group there and then ultimately come together to make the recommendations for any policy changes that would be needed within the state. And then finally, in section 14, we have an addition to NRS 62C015 that a child must not be placed in a state or local detention facility if the child is alleged to have violated certain delinquent offenses or criminal offenses if they were adults. Those would be trespass, minor in a gaming establishment, obstruction of an officer, false information, and there is reasonable cause to believe that a child is a commercially sexually exploited child, which is why you can see why the training is important, so that we're able to identify who is actually a victim, and that as part of their victimization, they are committing certain offenses. So that is the bill as I walk through it. I know that I want to say that MDT part may seem a bit overwhelming, but as I said, we are actually already practicing that in the two large counties. These recommendations that are coming to you were a part of some national groups that looked at what we do in Nevada for our victims of commercial sexual exploitation and made some recommendations to Nevada to say you need to put into statute some requirements. Those included the statutory requirement for multidisciplinary team, that included statutory training for certain people that work with children, and of course it included what I testified to, which was mandating the screening requirements. So with that, I would be happy to take any questions to clarify the bill.
Thank you for that presentation. With that, we will open it up. Assemblywoman Constantine has a question.
Thank you, Madam Chair, and thank you for this bill. I just have a question on the training. I'm thinking of foster parents. I'm thinking of all of these folks who we sometimes already have a hard time finding foster homes. For this training, who is paying for the training? Or is this training free for at least certain groups that are already burdened?
Bridget Duffy for the record. Thank you for that question. I'd be happy to clarify that. So right now, foster parent training is put on by the child welfare agencies. They have requirements, as you can already see in statute, for certain training. I think most recently we updated the statute for retraining around the LGBTQ community of children. Most of our training is provided online and they can watch it, and they are required to update that training yearly, so this would just be in addition to that training.
So just to be clear, and I have it on the record, there's no cost for this.
Bridget Duffy for the record. There would be no cost to the foster parents for this. I don't know what the agency would have to pay for to upload a training to them.
Assemblywoman Cohen?
Thank you, Chair, and thank you for the presentation. I'm looking in Section 5, Sub 5, the new language about attorneys appointed. So the appointed attorneys, these that are getting the training, these are attorneys that are representing the parents in a 432B case, correct? Those are the ones that are getting the training?
Bridget Duffy for the record. Assemblywoman Cohen, yes, it would be both parents' attorneys and children's attorneys.
Okay, and I'm sorry because I started to try to figure out if the parents' attorneys are mandatory reporters, and when you do that and you start going, this statute leads you to this statute, which leads you to this statute, so I haven't gotten to the bottom of the statute to figure out, are the parents' attorneys mandatory reporters, and are they going to be required after that training, are they required to report based on that training and just in general, what's the reasoning behind having the parents, attorneys get this training?
Bridget Duffy for the record. I know there are limitations on children's attorneys with regard to mandated reporting. I am not sure about parents' attorneys, so I will have to pull that statute up unless legal can tell us. And of course, all of the mandated reporting would be limited by whatever the requirements are that are currently set in statutes. So of course, we know that children's attorneys aren't required to report things unless other things are in play. So the purpose, the more people that interact with children that I can identify that a child is a victim or at risk of being a victim, the better it is for our children. And so when attorneys represent parents, in my opinion, I don't know if they have a different one, I think it would be important for an attorney to recognize why a child might be behaving a certain way, why a child might be, I guess, behaving a certain way is probably the best way to put it, that they're able to guide their own client into understanding their child's needs and why certain recommendations may be being made for their child to do certain things, why parents might be required to do certain things for their child, so that it's kind of all, because we are really a problem-solving court. So if everybody is identifying things and then they're able to counsel their clients on why their child needs this or that and not oppose that their child has to go to certain types of counseling, I think it just makes the system better.
Okay, thank you. I want to make sure that we're not doing any unintended consequences when it does come to reporting, but that does make sense, so thank you.
Thank you. Our next question is from Assemblywoman LaRue Hatch.
Thank you, Chair, and thank you for presenting. So my question is on Section 9 about these multidisciplinary teams. So in Section 9, it talks about how any agency that is providing child welfare services or any other relevant agency can create one or more teams. And so I just wondered if you could give some clarity there. Are we thinking there's multiple teams for the school district, multiple teams for agencies overseeing foster kids, multiple teams with the DA? And if that's all happening, how are we ensuring that they are communicating with that many separate siloed teams?
Bridget Duffy for the record. That's a really good question, Assemblywoman. So during the course of creating the language around the multidisciplinary teams, the reason it's a child welfare agency or other agency, relevant agency, is because in some jurisdictions, they're led by law enforcement agencies. So in Clark, our local MDT is led by our Metropolitan Police Department and brings everybody together. Now, in other counties, they may want the child welfare agency might want to be the lead, so we allowed that open for each county and how they would rather do it. As to whether or not there would be different teams running, that is a possibility. However, there's so many different requirements of the team, so there could be an MDT that's really just looking for the research and development of practices, right? So child welfare agency could create an MDT in order to identify the certain needs for kids that were missing within the community. Law enforcement in Clark right now, our MTT is created to make sure that we are giving the appropriate services to our victims, that it is coordinated services, especially if the case is going to court, so that they have the advocate with them, they're able to court to prosecute the sex trafficker. So we have all of those different things. So yes, there could be multiple teams, and I think that the creation of the executive committee is really going to be that umbrella organization that oversees what's going on and is able to kind of guide that training and responsibility.
So I appreciate that answer. Then my question is, I know that you created that umbrella organization that you just described, but it says in this bill that will be created from the members of the multidisciplinary teams. And so I'm wondering, how can that organization organize all of this if that organization can't be created until all these other teams are created?
Bridget Duffy for the record. Woo, okay. So DCFS, the Division of Child and Family Services, will create that executive team, and then they will pool the members from each of the each of the teams that are in play. So we already have teams in play in Clark and Washoe. We can already identify who the members are of those teams. This is not, this practice is already going on. We are now just making it a statutory requirement so we can get some uniformity about who is supposed to be there and who is, what we are supposed to be doing. So it's already in practice. So I don't think that there's going to be that issue of we don't have anybody to start pulling into the executive team. Also, we already have the commission for oversee the commercial sexual exploitation issues of children, and that I see is kind of becoming that executive, or I shouldn't say I, but the conversation within the commission when creating the recommendations for this bill, where we see that kind of becoming that executive team because they're already in place. This DCFS already helps guide us through that commission. So they would just naturally turn that into the executive, and then we'd all just kind of fall up underneath of it.
Thank you, Assemblywoman. Our next question is from Assemblyman Gray.
Thank you, Madam Chair. Good morning. How many hours are foster homes and the people you're targeting, how many hours of training are they already required to have for their licensing? And how many hours would you envision this training adding to it?
Bridget Duffy for the record. Assemblyman Gray, I'm sorry. I do not know how many hours each foster parent is required to have. I can definitely get you that information since I work closely with child welfare agencies and let you know. There is not a specific time amount. It's just a requirement for every 90 days and then annually thereafter. I know that the training that I do, along with others for juvenile probation officers, is a 2-hour training. So it could be up to 2 hours in order to get the message out there, what needs to be looked at.
Thank you for that. Our next question is from Assemblywoman Mosca.
Thank you, Chair, and thank you for this. My question was similar to the Assemblywoman's question on Section 10. It talks about a multidisciplinary team shall, and so you're sharing that we're already doing this. I'm curious for the coordinated response that meets the needs of the child throughout the criminal justice system. How long is that typically taking, and or are we hoping that this helps with that time? And how many young people are we talking about right now?
Bridget Duffy for the record. I just want to clarify, if I may, how long is the coordinated response taking? Is that what the question is?
Yes.
Okay. So, thank you. So, right now in Clark, we have a fantastic coordinated response. So, when Metro's Vice identifies a victim of commercial sexual exploitation, whether that be because they have solicited or they're a minor in a gaming establishment after hours, or they are trained to identify. So when that happens, they have a process where they call out advocates to the scene to meet with that child. So that process is already starting. And then, so tomorrow, when I'm back in Clark County, I actually have a multidisciplinary team for this population of victims scheduled tomorrow afternoon. So all of those children that have had contact will be on this list, and we will make sure that, where we are within the court process of processing any identified trafficker, making sure the advocates will tell us how they're working with the child and what services they're being put in place. Sometimes we talk about other services that are needed. Real random services, like sometimes a child will mention she wants her tattoo removed because they'll be branded or tattooed. So it all happens pretty quickly, and we meet monthly on that multidisciplinary team. But the coordination in Clark is immediately upon identification because our advocates are working in the middle of the night to go out to the scene. And pretty soon it's going to be our child welfare agencies making sure they're coordinating in there.
Follow-up, Chair. Just for the second question of how many?
Bridget Duffy for the record. I think it's a low number because, again, I don't know that so as how many as law enforcement identifying? It's just law enforcement, right?
How
Sorry to ask
many?
that question.
It's okay. How many young people are we identifying through this process?
So on my MDT calendars, there's probably anywhere from 20. Sometimes they're duplicated because we bring the same child back, not because they're committing, because they've identified twice, but just to follow up. So I think we average probably about 20 cases we review a month. Identification, I know Vice has those numbers for last year, our Metro Vice. I think it's probably about 100, a little over 100 children that they have identified only through law enforcement contact. The hotline, our Child Protective Service hotline, does not require law enforcement contact, so anybody in the community can call if they believe that they have identified a child who's a victim or at risk of being a victim, and that number is bigger than 100. I'm not exactly sure how many we are getting a month, but that's the addition of those mandated reporters in NRS 432C, so teachers, doctors, they all need to be reporting, and then just a regular citizen can report as well. So the common theme, as somebody who's been living this system and trying to figure out how to best help and protect these children, is there are a lot more. We are just not identifying them, which is why that bill from Friday came out, that we need to do better identification, because the faster we can get services in and the faster we can get them to kind of get out of that cycle that they're in, the better chance we have at success for them.
Assemblywoman Hanson.
Thank you, Madam Chair. Always good to see you, and I always feel I need to say thank you for all that you do in this space with child welfare. Having been involved over the last maybe 6 or 7 months with the Northern Nevada Sex Trafficking Task Force and attending some of those meetings in the summit, I've become painfully aware of what I wish I didn't know, and that understanding the psychology, I really see the need for this training, because I was surprised at how there were things I never would have thought of when it comes to how you might identify this child, the behaviors, some of the pushback you might even get from these children. But where I have some concerns, and I'm really glad Clark is doing this and Washoe, help me understand how we're going to, how this impacts the rurals. Are they going to be, is this going to be a heavy burden on them with these multidisciplinary teams, the coordination? Have you seen, have you engaged with the rurals much on this bill, and what has their response been?
Bridget Duffy, for the record. Thank you for that question. We did have rural representation on the statewide commission. And this was taken to the full commission. We had a subgroup that worked on the language, and then it was taken to the full commission, and any concerns that were raised during the working of the language have been identified. And so, for example, one of them was around making sure parents were involved if we were getting private health information, and making sure that we at least made efforts to notify parents and guardians of that. So any concerns that were raised, outside of that, I have not heard of any other concerns, and maybe today we will hear of some. I don't know.
Thank you. We have a question from Assemblywoman Summers Armstrong.
Thank you very much for your presentation. Last week, I believe it was Friday, we heard about a similar piece of legislation, and it dealt with folks who provide services in shelters. And one of the issues was consistency in training. There's a different way to do things in the South, in the North, and also in the rurals. Is there any discussion with those groups, because these are similar populations that need to be served, so that the education that is being given is has some basis in consistency? There may be some some changes or things that are just slightly different as people get older or the circumstances are different, but I'm concerned that that the training might, as my colleague said, just not be consistent and people are in silos and they're doing this. And my next question would be, what is this going to look like for human capital? Are we talking about expanding teams in the DA's office, more employees for the state of Nevada that'll have to run this, more employees, a needed expansion of police personnel to do this type of work? Honestly, how is this going to affect the need for human capital? Thank you.
Bridget Duffy for the record. Assemblywoman Summers Armstrong, I appreciate the issue around the consistency in training. I think that is a very big issue. We do not address that in this bill, that everybody has to do the same training. It's, find training that works and get it done. Within the commission, the statewide commission, we had a subgroup around training so that we could find a training that would work across the state and statewide. And I think that is still a mission within that group, to make sure that we are offering everybody we can tell them there's a catalog of training that is evidence-based, best practice, informed, for that different population. Within the DA's office, as far as training, we put on our own CLEs. And we specialize them. Like for me, for the juvenile division, there are so many more, there are relevant topics for me that may not be relevant to criminal, and that I want all my attorneys trained on, like childhood brain development, adverse childhood experiences, and how children. So this will be a natural fit for me to just have that CLE brought in. It was raised to me by my public defender friend that, who do we foresee is going to be doing this training? Of course, in Clark, I would partner with the public defender's office. We can sit and do the same CLE. CLE is continued legal education, so attorneys have to get a certain amount of credits each year. For the police, they already have a training. It's virtual. They can log in. We discussed this during the creation of this bill when probation departments were like, well, where are we going to find this training? Our police departments already have a training catalog. This is one of the training pieces that peace officers have, and so they're able to use that same catalog of training. Child welfare agencies incorporate this in Clark, at least already, in training new employees, so they'll just expand it out to their current employees. They touch on this, but it is not all consistent, which is your point, and I get that. If there's any way we could find a way to make it consistent, I'm 100% on board for that. But I think that's going to take the statewide commission to say, this is what we want everybody to be trained on, this is what the training looks like, and then and putting that out there. One big issue is that nothing that we do for this population of children has come with any money. So everything we do is ragtag team of people trying to do the best that they can. So yes, we could pay for really great training, but nobody is providing the funding to do that. And so this is a policy committee. This is good policy, and I can't force people to buy a certain catalog of training, but we'll do our best. And any little bit helps. Human capital, I don't see a need. I don't see that we're going to be creating new teams of anybody. Most of this is already going on. It's just not statutorily required. And it was recommended by national organizations looking at our state to say, you need to require this because it's only as good as the people that are in the positions they're in now. And we need this to be ongoing after that.
Thank you for that. We have a question from Assemblywoman Gallant.
Thank you, Chair. So I think this is amazing that you guys are all working together, and especially with no money, I know that's difficult. I'm curious, though, is there any thought about reaching out or offering with the various organizations and the training that they are providing for some organizations that haven't been named but would see children to be, and I, off the top of my head, I'm thinking libraries. It's a place to stay cool. It's a place to stay warm. You have free internet. And that would be a place where kids would go sometimes, and that the librarians could identify this. Probably not at this mass population, but in my mind, I'm like, one is better than none. So, I mean, even with the statewide commission that you guys are looking at, or with the various municipalities and the police departments, is there any opportunity for organizations that want to have this training within like the libraries and whatnot to just be part of the team and part of this grassroots effort?
Bridget Duffy for the record. So when we did this, when who to require with training, we looked at the members of the commission to say, okay, well, because the Attorney General's office was there. We looked at all of the children's attorneys, we looked at all of those people and said, okay, now we're going, we felt we had, I'll use the word jurisdiction, to make it required. I thought it was a little bold. We were even stepping into the schools, but I know that the Clark County School District has already talked to me about the mandated reporting requirements, training, and things like that. So we took that bold step to say, hey, you have 300 and some thousand of our children in your care every day. You are our biggest population of identification. We need you on board for this. The libraries, I think we would feel like we were just going out too far, but if anybody ever wants it and not statutorily required, we would be happy to come out, and I would be happy to find somebody to come out and talk to them. So.
Thank you. And Ms. Duffy, I think that's where my question is that first it's interesting because there has been such a combination of, different professions, right? And so we've got members of the AG's office, we have attorneys, we have school personnel, we have foster parents, we have, just a huge group of people, again, the ones that primarily are involved with children. And yet the training will be inconsistent in the material and the content as well as the delivery. But when we talk about the schools, and so some of the things we know about schools is schools are basically the number one reporters, right? Not just mandated reporters, but because of literally having and spending so much time with children and learning childhood behavior. And I never ever want it to go unsaid that other students are the real MVPs in this as well, because other students are always stepping up to ask for help, report things, let staff know what's going on. So they really do a remarkable job helping their fellow students as well. But I know in 2019 it was reported either in Judiciary or HHS, I don't recall which one, that when it came to suicide prevention among youth, that 51% was coming from the schools. We know that during COVID, when the buildings were physically shut, that CPS reports just plummeted because, again, the number one reporting's coming from the schools. And so, again, based on what's already happening and the training that's already there, I guess my question is, and following a little bit of what my colleague was saying, is what is the expectation then? Because we already know the reporting and such is happening and the services. So what is the expectation? Is there a belief that we will find so much more percent of trafficking? Is the intent of this to really deliver services to the youth, or to be able to on the criminal side get to the arrest and convictions of the perpetrators? What is the real essence of this? And I also want to say, I know that this bill came through Health HHS, and that so many of us weren't privy to those discussions during the interim.
Bridget Duffy for the record. Thank you for that question. So the purpose, I'm going to say the last purpose in my mind right now is about prosecution of traffickers. That's with regard to this this bill with training. Okay. So with the training portion of this bill, it's the purpose is for that early identification so that they can first do the assessment and then obtain services. So, and identifying a victim of sex trafficking is not the same as identifying a victim of child abuse. Sometimes symptoms overlap, but sometimes they do not. And so certain things like a child has the tattoos, so dollar signs on the hands, neck tattoos. Those are traffickers' ways of identifying their property. Multiple cell phones, a child who's suddenly coming to school with additional money or looking like they have things that they didn't have before. Children that are sleeping in class a lot. So in a combination, because they've been up all night being trafficked, but they still go to school because our girls and boys still go to school. Like a combination of all of those things together says, ooh, I should probably call the hotline, report that I have some concerns, let the hotline then, the experts, hotline being our child welfare agency, which is required by federal and state law to take those reports and identify whether or not this child needs an additional assessment and then provide services if they are deemed to be a victim or at risk of being a victim to their families and the child. So that's the purpose of this, is not to, I'm not worried about the criminal prosecution at all. It's really just making sure that all eyes are on our kids and we're identifying them early.
Maybe it was my misunderstanding, but I thought I did hear you say, Ms. Duffy, that it was about the prosecution of
Bridget Duffy, for the record, the multidisciplinary team is a different, so I was focusing, like, the first thing I said was focusing on the training.
Okay.
To identify is not about the prosecution. That's those sections. The multidisciplinary team has several goals. One of them is to make sure that we are all communicating for that prosecution of the trafficker. That's one of the goals. Other goals include the services and coordination of the efforts to that child.
Okay, thank you. I don't believe I see any additional questions at this point, so I will. I guess I'm okay with my questions as well. I still have some questions that I can take offline, but I think whenever it comes to bills revolving training, that we always have the same sentiment about consistency and quality and ensuring in the delivery part of the training. So, and I think that members have echoed that sentiment as well.
Bridget Duffy, for the record. I just, to comment on that, I think there's a fix to that. Because we have DCFS as the ultimate hub of the agency that oversees our commission, of, overseeing the executive MDTs, there could be a fix if this committee wanted the identification of the training to run through them and then to be sent out. So we have one agency with input of everybody, because that's what we do on the commission. But again, I'm not the whole commission, so I can't make that decision. But I'd love to have those conversations. I know my friends at DCFS are not here today. I'd love to have the conversations with them to see how they feel about putting that in. And of course, I am one member of an entire statewide commission, so it's not CSEC according to Bridget Duffy. I'm doing my best to send the message from them.
Right. Thank you so much for that. And we do appreciate that. Thank you. With that, I will go ahead and open it up for testimony of Assembly Bill 238. So anyone that would like to testify in support of Assembly Bill 238, please approach. Also remember to say and spell your name so that we have it accurate on the record, please.
Good morning, Chair, members of the committee. For the record, my name is Serena Evans, Serena EVANS, and I'm the Policy Director for the Nevada Coalition to End Domestic and Sexual Violence. As I've previously said before this committee timely intervention and connection to resources is the key to being able to help minor victim survivors escape commercial sexual exploitation and live happy and healthy lives. We also know that exploitation often happens at the hands of a family member or a trusted adult, and so many victim survivors don't know how to ask for help or even identify as victim survivors. So increasing the training for those working with children on identifying and assisting CSEC victim survivors is a positive step in increasing the likelihood that these individuals will get the intervention and the safety planning that they need. Additionally, because of the complexities of CSEC cases, multidisciplinary teams and executive review committees will positively impact victim survivors and the agencies interfacing and supporting these individuals, so we appreciate these victim-centered measures. Thank you.
Good morning, Chair Miller. Good morning, members of the committee. Jason Walker, WALKER, Wash County Sheriff's Office. I believe the more resources we put into this area, the better in identifying these child victims, testifying obviously in support of AB 238.
Good morning, Chair Miller and the Assembly Committee on Judiciary. My name is Chris Reese, RIES, representing the Las Vegas Metropolitan Police Department. We feel this bill will bring awareness to these crimes. It will help us identify more victims to provide more services and hopefully ultimately bring more perpetrators to justice. Assemblywoman Moscow, I work with my colleague to get those numbers for you. I'd also like to thank Ms. Duffy for her presentation and the Interim Committee on Health and Human Services. We support this bill. Thank you.
Good morning, committee. Reagan Comas with R&R Partners representing Awaken, and I will just echo the comments of the previous speakers and voice our support.
Is there anyone else here in Carson City that would like to testify in support? Not seeing any. Broadcasting, please open the lines for anyone that would like to testify in support of AB 238.
Callers, if you would like to testify in support of Assembly Bill 238, please press *9 now to take your place in the queue. Again, if you would like to testify in support of Assembly Bill 238, please press *9 now.
Good morning, Chair Miller, members of the committee. My name is Lauren Boytel, Lauren Boitel. I chair the Nevada Policy Council on Human Trafficking. On behalf of the Policy Council, we would like to formally support AB 238, as we feel it is important to ensure that any persons who interact with and impact at-risk children in CSEC in any way be appropriately and robustly trained. Further, we feel the creation of the multidisciplinary teams with oversight from the Executive Committee will better protect and serve child victims in a more comprehensive, thoughtful, and appropriate manner according to their unique needs. For these reasons, we respectfully request your support for this bill. Thank you.
Chair, there are no other callers to testify at this time.
Okay, thank you. With that, then I will open it up for testimony in opposition of AB 238. If there's anyone in Carson, please approach.
Good morning, Madam Chair. John Piro, John Piro, from the Clark County Public Defender's Office. I hate coming up to oppose a bill that's going to be putting good things in place. So, pursuant to the rules of the committee, I'm only going to talk about Section 9 that creates and codifies multidisciplinary teams. We have a whole juvenile public defender's office that was not consulted with nor talked to about putting some things in place. We are sometimes the people that are closest to this issue. Both our attorneys and the attorneys from the Legal Aid Center of Southern Nevada have done battle with the the district attorney's office when it came to locking these young girls up. So we've had disagreements. Sometimes we are close to the issue but not brought in to discuss the issue. So that is our problem. If we're going to codify a whole team, I think this team needs to be robust. I think it needs to look at all angles and who could be part of the solution. So that is where it stays there. The team itself, Sometimes we create these committees and they seem to be law enforcement heavy, and we all come from different perspectives. So I think it's important to have diverse perspectives, because this team smacks of everybody is talking about me, but nobody is talking to me. And so that, I think, is important when we move forward on a piece of legislation that's going to change something. So hopefully we'll get to a point where we can adjust this bill and be in support. Thank you.
Good morning, Chair, members of the committee. Erica Roth on behalf of the Washoe County Public Defender's Office. I echo the sentiments and statements by my colleague, Mr. Pirro. I think it's important to remember that our clients are victims of sex trafficking too, and so that they need a voice at the table. And then I'll briefly just add, as Assemblywoman Cohen touched on, I think there's some concerns in regards to conflicts of interest that may arise when we're talking about attorneys who represent parents, and just thinking through the policy objective. But so pursuant to the rules, I oppose as written, but I think we'll be able to get to a place of agreement. Thank you.
Is there anyone else here in Carson City? Not seeing anyone. Broadcasting, will you open the lines, please?
Chair, there are no callers at this time to testify.
Then I will go ahead and open it up for testimony in neutral here in Carson City. Not seeing anyone in neutral here in Carson City. Broadcasting, is there anyone on the lines for anyone testifying in neutral?
Chair, there are still no callers at this time.
Okay, thank you. Then with that, I will invite the bill sponsor back up to make any final remarks.
Thank you, Chair Miller and members. Bridget Duffy for the record. I just want to thank you for listening on behalf of the statewide coalition for the prevention of commercial sexual exploitation of children. Thank you.
Thank you so much. With that, I will go ahead and close the hearing for AB 238. The last item on our agenda today is public comment. Again, anyone wishing to make public comment, I ask that you keep your comments to 2 minutes. Is there anyone here in Carson City? Not seeing anyone in Carson City. Broadcasting, is there anyone on the lines?
Chair, the public line is open and working, but there are no callers at this time.
Okay, thank you. With that, then, just a few announcements for the rest of the week. Tomorrow, we will begin at 9 a.m. And you're okay with that? Okay. All right. Thank you. So I will see you all at 8 a.m. tomorrow morning. 9 a.m. tomorrow morning. This meeting is adjourned. No, it's 9 a.m. tomorrow morning. It's 9 a.m. tomorrow morning.